What the lawsuit is about is the fact that this is not just a constitutional amendment proposal. That's the way it's being presented. You can't tell when you look at the proposal. You can't really tell what else it does, but what else it does is to basically rewrite the Gaming Control Act. That was, as many of us remember, was the subject of an initiated law in 1996. So without disclosing the fact that the gaming control law is being rewritten, and without disclosing the fact that that was an initiated law, that is the bulk of what goes into this proposal. So you have a constitutional proposal that basically eliminates the language that voters incorporated into the Constitution in 2004. That's language that says before you can expand gaming in Michigan, you have to have a public vote. That's deleted from the Constitution. That's the constitutional change. Most of the rest of what's in this proposal are amendments to the Gaming Control Act, the initiated law of 1996, and they're very extensive. They change the tax rate. They significantly narrow the authority of the Gaming Control Board. They modify the allocation of money between the city and the state, the wagering tax revenues. Some of the provisions apply only to the new casinos. Some apply to the old casinos and the new casinos. So it's kind of a patchwork. But it basically is a rewrite of the Gaming Control Act. What our belief is that if you want to amend an initiated law, you've got to do that through the same procedures that you use to pass the initiated law in the first place. In other words, you circulate petitions. If you have enough signatures, the petitions have to be presented to the legislature. The legislature has 40 session days in which to either adopt those changes or reject them. If they reject them, they can put their own proposal on the ballot, and then it goes out for a separate vote on the legislative changes. That's the way that you amend something that was originally adopted as an initiative. Here, they've combined the initiative changes, or the amendments to the initiative, with a constitutional change. We don't think you can combine the two in a single petition. So there are two basic arguments here. First argument is our belief that in order to amend an initiated law, you've got to go through the same process that the voters did here in 1996, change it the same way by going under Article 2, Section 9 of the Constitution. And then secondly, you can't combine the two, a constitutional amendment and a legislative amendment in the same proposal.
And Article 12, Section 2 is very clear how you amend the Constitution, but Article 2, Section 9 is very clear as to how you amend initiated laws. And we think it's clear that there's absolutely no authority or ability to mix the two procedures together. And as Peter pointed out, there are at least 11 major conflicts between this proposal and provisions in the Michigan Gaming Control Act that are substantial. Michigan Gaming Control Act was amended in 1997 after the initial initiative was passed, and it can be done. It takes 3/4 vote of members elected to and serving in the legislature. And if that was the desire, the policy and the practices articulated in Article 2, Section 9 should have been followed. They should have sought an amendment to the initiated law, and they should have followed the steps that the Constitution outlines. We're very confident that the claims and the arguments that we've raised in this suit that we're going to be filing in the Court of Appeals are going to be successful. We're going to ask the Court of Appeals, because of the timelines that are involved, to act quickly. Because we're very much aware of the fact that irrespective of what happens at the Court of Appeals level, that the parties will probably take this case beyond that level. So we're on a very tight timeline with the petitions having just been filed, and we're looking forward to make our arguments in court.
This is the first time that we know of, and we've looked pretty hard at this, that you've had a constitutional amendment and then an attempt to change an initiated law put together in the same ballot proposal. Nobody's ever tried that before. John and I and others who worked on this lawsuit do a lot of gaming law work. We're real familiar with the Gaming Control and Revenue Act. But I would venture to guess that there are not more than a handful of people in this state who would look at this petition and be able to tell that most of it is a rewrite of the Gaming Control Act. It's not apparent from the face of the petition, and unless you're real familiar with the Gaming Control Act, You can't see that, which is the other problem. Voters are not being told that they are being asked to undo in a lot of cases, but basically rewrite what they voted on in 1996.
You know, was it just poorly written? And that would be a question for their lawyers to answer. Or what are they trying to pull over? I think you look at the fact that we don't know who owns the land. You know, some of the investors aren't identified at some of the locations. Some of the locations have LLCs where you don't know the full ownership of the property, and these ownership rights can be sold in shares to other people, which opens the door for the undesirable types to come in. So there are just so many questions that we're getting into as this is investigated more fully, and ones that the public has a right to know, and also to know that it's just a straightforward violation of the Constitution that we have in place in Michigan today.